following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss pardons in Sri Lankan law. What legislature governs pardons, and can justice truly be achieved through the process of pardoning? A very good evening, and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, tonight's topic is something that we have touched briefly on in the past, but I'm pretty sure it's important for us with recent developments to get further into detail on this topic, and that's on pardons and presidential pardons. And to speak about this topic, we have someone that's not a new face on the show, but it's been quite some time since we've had him back, and that is President's Counsel Silva. So thank you very much for taking the time. Quite a packed discussion ahead, so we should probably get right to it. Well, before we do, here is a little bit of a breakdown on how exactly we're going to approach this topic. First, we'll be giving you the basics of pardon. What is a pardon and why do they exist? What's its reason and what's the negative connotation around presidential pardons? Next, we'll be going into the current context and also cases that we have seen unravel in real time. And finally, we'll be talking about the international standards and also the reforms aspect and the future of presidential pardons in Sri Lanka.
Hello, my name is Sandamari. I'm a chemistry teacher. My question is on pardons. What is pardon and what is its history?
All right, so well, without any ado, let's get right into the discussion. We have quite a bit to discuss as well on this very antsy topic. A lot of people tiptoe around it because of the connotation surrounding pardons in its essence. But before we get into any of the real world and the current world specifics, I think it's important for us to give a little bit of a breakdown to the viewers on what exactly a pardon is. What's a pardon, sir?
Yes, now when we consider the word pardon is forgiveness. So we give some sort of forgiveness to people. In this scenario, we are concerned about the people who have done something wrong, which we say you all have done something, but it is not good for the society. But considering the facts of the case and the situation and his conduct, everything has been should be considered, and then only consider whether to give a pardon or not. So this is a crucial thing which has been recognized by all over the world, and especially the America. They are doing it in a way that people are not happy in some way. So for example, the during Obama's time, they have released 1,700 people by giving the pardon, and then Trump also has given 150 people. So those matters, considering the country, of course, they say sometimes you misuse it. So pardon, of course, why we are going to give in this country. So our constitution in 1978 had recognized this special area where the people have gone to courts, and then finally, in our country, magistrate court, then the High Court, and thereafter Court of Appeal, Supreme Court. All these courthouses, they are going to hear the criminal cases, and especially High Court is going to have the grave crimes, where we are concerned more about those areas. And then after the conviction is given, whether it's a trial at bar or single judge or a jury trial, then thereafter it will go to Court of Appeal. Court of Appeal will consider that factor, and if the Court of Appeal says yes, we will affirm the judgment given by the High Court, then on legal issues they can go to Supreme Court. Finally, Supreme Court is going to determine whether the conviction is going to be set aside or not. So if the Supreme Court is of the view that it should be affirmed, then that is the end of the matter. So then the person should go into jail and he has to go suffer the consequences. In this scenario, there may be some sort of miscarriage of justice. Miscarriage of justice in the sense, sometimes because of his not ability to pay the money to the lawyers, retain a lawyer, and go for further judgments can be challenged in different courts. He cannot go further. The classic example which I can show you is when there was a case where two accused were charged for rape and murder, and they were convicted in High Court, and thereafter those two people appealed to the Court of Appeal. A Court of Appeal has given the same order. So then the one person, he has retained counsel and he has gone to Supreme Court. The other person, he doesn't have the money. So because of that, he didn't appeal against the conviction. So then the Supreme Court has decided that both were charged together. Common intention, rape and murder. So Supreme Court has decided that the person who appealed against the order of the High Court, Court of Appeal, Supreme Court has decided that it is wrong, and then he was released. He was acquitted. So then what happened to the second person? So that was the issue. So that type of a case, the president can consider that factor. It's on legal principle, and then thereafter he can be released. Is one way. Then another incident is that where there was a recording of the aggrieved party lady. It was a rape case. So that person, when he was going out of the courthouse, he recorded the conversation between that lady and the accused. She has stated, you didn't marry me, and because of that my brothers got together and fabricated. On her own voice, that recording was there. But unfortunately, he didn't have a discussion with the lawyer, and finally he was convicted and his appeal was dismissed and he was serving the sentence. Then only it came to light that the recording is there. So that type of a situation, the president should come into the scene and then consider whether it is legal to keep that person indefinitely because of that charge. So there are various incidents. Then because of that, the legislature has considered that factor, and in the Constitution itself, Article 34 of subsection 1, it is clearly stated the president has the power to grant pardon for the person who are necessary, important to give pardon. That is how the pardon comes into play. But as far as the death sentence is concerned, so pardon should be given in a proper way. We will discuss later.
Exactly, sir. We do have to get into the specifics on the death sentence as well, because that is a completely different purview. But sir, in your opinion, what do you believe is the key reason? What is the biggest reason as to why a pardon or presidential pardoning system should exist in Sri Lanka?
That's why I inform you. I personally feel some people, they don't have money. So because of that, they can't retain a good lawyer. So that does not mean moneyed people can only retain a good lawyer. But the fact remains, it's a fact. And then if they are in a position to retain a lawyer in a proper way, and then they can go to trial and then get his version, and thereafter he can be acquitted. So if it is not happening, the classic example where I have given you, so in that scenario, they have to have some sort of a remedy where they don't have to pay anything. They can just inform the president about his position, and then even the prison authorities can inform the president about the present situation. Thereafter, the president will go into that and then get all the details and consider whether it's an appropriate case to consider a pardon. So now, in our country, we saw very recently 779 people were released because of New Year season. So likewise, New Year and Christmas, Vesak and Independence Day, the president, since the president has the power, he releases some people giving pardon. So those are minor offences where some people they are not in a position to pay the fines. So then they are languishing in remand. The people have to pay their day-to-day life thing. So the tax money will be given to them to serve them. So because of that, considering those factors, they will be released. And then for minor offences, if they are being sentenced to jail, then the remand authorities can inform the president about that also. So in a situation like that, that is the very recent thing that 779 people were released. So those things, of course, it is necessary to have that. So only thing is, our people should understand the law is different. The constitution provisions are different, but when a person is going to adhere to that or he is going to implement that, the person will abuse it. Abusing is a different thing. That does not mean that because of the abuse, then we have to abolish that particular section or particular clause. It should not be done. It is important because sometimes, somewhere down the line, there will be injustice. So to solve that problem, only final part, we don't have any other appeal. So earlier we have to go to England and have the final appeal, but here Supreme Court is the finality. So hierarchy down the line, Supreme Court is the most important area, judicial system we have. So once the Supreme Court has given the final judgment, then we can't do anything apart from that. So because of that, this constitution provision was there, and now it is Article 34, subsection 1, it is very clearly stated in that way.
It is a last-ditch effort. Of course, it's something that is very final, that after even the most Supreme Court of Sri Lanka, after such a decision only will we be able to approach a presidential pardon. So I think it's important for our viewers to understand, now that we know the significance behind the existence of a pardon, could you explain to us exactly what the process is when it comes to the application, when applying for pardon? How do you actually get through that process?
Yeah. Now, in a normal situation, as I told you, in a not the death sentence type. So a normal situation, a person can apply by through a lawyer, or somebody of relation can apply to the president, sending a petition with details and asking the president to consider about pardon. And even the prison authorities getting all the data and thereafter submit to the president about the pardon. So those are the things that can be done according to the normal day-to-day process. So once the request or the petition received by the president, he has to act up on the way that it is there. So in a normal case, the president does not have to go into details. If the details are available, he can satisfy with that and take a decision. But as far as the death sentence is concerned, those are the main areas where people are concerned. So as far as the death sentence is concerned, it is very clearly stated in that constitution that president has to follow the necessary guidelines given by the constitution. Procedural aspects are there, so he has to follow the procedure. Otherwise, it's illegal. So if he follows the procedure and then take an decision with reasons, then thereafter nobody can challenge it.
Right, so apart from the procedural aspects, I think we should get a little bit into the death penalty aspect as well, because that is something that our viewers would very much curiously like to know about, because that is ideally the part of the pardon that's actually coming into scrutiny in the current context. We don't have much time, but we should discuss this. When it comes to the death sentence and when it comes to pardons in that specific area, how vastly do the processes differ? Now, we just learned about that there is a specific legal process that the president has to follow through on in order to have a valid pardoning process. How different is it compared to minor offences?
Yes, now minor offences, as I inform you, President is not in a position to take all the details from various authorities. Here, of course, it is clearly stated, if a death sentence is given and if he is going to consider whether to give a pardon or not, then he has to call a report from the particular judge who heard the case. Now, in a trial at bar, there are 3 judges, but in a normal case, day-to-day case, the judge, one sitting judge, should give a report to the president about the case where he has determined. So, once he received these numbers and then the particular areas how he has determined the case, then thereafter he will send it to the Honorable Attorney General to get his opinion. So he will give his opinion accordingly, and then thereafter with all those details he should send it across to the Minister of Concern, Justice Minister. So Minister will go through all the details and finally he will give his recommendation to the President. Thereafter only he can take a decision. But there are other things also in this particular death sentence is concerned, because now in a recent development we have called the Witness Protection Act. That particular act is a very powerful act where it is very clearly stated that once the decision is taken about a particular incident, the aggrieved party should be given notice. They should be informed what actually happened. Now, as far as that particular case is concerned, in a particular death sentence case, they know that the accused had been given a death sentence. Now, thereafter, if the President is going to take a different view, he should inform the aggrieved party and get their opinion as well. So that does not mean he is bound by that, but he has to go through that. He has to give notices. They should be informed, and once they are being informed, they will be represented by a lawyer, or on their own they can send their views to the President. Finally, if he has taken a decision to give a pardon, he should give reasons. In all our law, it is very clear in our courts houses also, once the judgment is delivered, it should follow the reasons. If the reasons are not given properly, then the higher court will decide it is not a correct order. Likewise, in this scenario also, if the President has not given his reasons, then it will be a null and void order. So now very recent judgment if we discuss.
Actually, we need to get into the recent judgments as well in a much broader context. Unfortunately, I have to cut you off here, sir, because our time at this segment ends now, but we will definitely pick up on the recent judgments, specifically relating to such a vast area that is pardons, and also on the death sentence aspect as well, how serious the repercussions are if reason is not followed. Before we get into any of that, let's take a very short commercial break. You're watching Lawland and Liberty. We'll be right back. Welcome back to Law, Land and Liberty. We're in discussion with President's Counsel Silva, and we were talking about presidential pardons. Very vital discussion as well because of just how politically charged, socially charged, and completely different some views are relating to this entire topic. And we just, unfortunately, sir, I had to cut you off before we got into the specific cases as well and the current context. If you could continue where we left off, sir, relating to...
Now, at the moment, we know there are specific areas where people are concerned, especially the Jude Jayamaha case, where in 2019 President Sirisena has given a pardon, and Galaboda Gnanasaratera's pardon in 2019 also in the same year. He was given 6 years rigorous imprisonment, and he was given the pardon. And then Gotabaya Rajapaksa came in and he gave pardon to Sunil Ratnayaka, that is in 2020, and then subsequently the famous judgment of recently, where this most of the people they have discussed, and then the judgment was delivered with regard to the pardon because it was challenged by Domingo Silva's judgment. So when I discuss these matters, the two of the judgments, two of the orders, that is Galaboda Gnanasara and Jude Jayamaha, it has been challenged and still it is pending. But Domingo Silva's matter, it has been gone into the Supreme Court, and earlier, there was no provision where the president, once the president has given the pardon, the people can't do anything. But after the 19th of Amendment, the people had the right to go to the Supreme Court and challenge the pardon given by the president. So that was a great move as far as the law is concerned, because if the president has not taken proper adequate procedure, followed correct procedure, then the people are entitled to go before Supreme Court, which they have done in 3 occasions, and that the recent one is Domingo Silva's matter, where they have challenged it, and 3 bench had decided that having gone through all the aspects, whether he has taken the necessary steps to call 3 reports from the judges, that is trial at bar. Because of that, the 3 judges have given their views with regard to the case, and then after he received it, he has sent it across to the Attorney General, and even that there also Attorney General has given necessary guidelines to act upon. So there, with those guidelines, he has sent it across to the Justice Ministry. Justice Minister has given his opinion, he has given recommendation. I don't think he has given to release that, but he has given some recommendations of his, and thereafter only the Gotabaya Rajapaksa has taken a decision. But the grave error was that he has not informed the aggrieved party. The judgment is very clear. Justice Surasena has very clearly stated the president has not followed the 2 important areas, where one important area is he has not informed the aggrieved party, and aggrieved party was not represented by when the decision is taken. Then the final one is that he has not given his reasons to release the person. So what I see is that the 3 bench has decided that because of those errors, we are not in a position to affirm that pardon, and because of that, the pardon was, according to the Supreme Court, they say it was null and void. So that is how it goes. So if the other cases also, when it comes to the argument stage, the Supreme Court will go into details and see whether the earlier president has followed the correct path or correct procedure to give reasons, and whether they have informed the aggrieved parties as well. So if the material is quite correct and the material is available, then the president can take a decision. Now, in this particular scenario, my personal view is if the president has gone through, having informed the aggrieved party and then gone through the telephone conversation which were published in social media, where the conducting investigation officer is discussing with a parliamentarian about the judgment before it is delivered. That's a grave error. That's a grave thing, injustice to the whole case. And not only Domingo Silva, my personal view is all accused have been convicted there should be released because of that particular conversation. So it has not been brought into consideration. My personal view is still, if they are being properly sent to the president can take a decision, because I personally see that it is a grave injustice. That is why this particular section, particular article is there. So we have to concentrate on those things, and then only we can see whether it is important or not. So people should understand that if they are not in a position to show their all grievances, all their defenses to court, and then if the lawyers have done some wrong things, or the courthouse in the judgments, there may be wrong judgment, so then the president can come into the scene, and then a president can take a decision. So that is why this aspect or this particular particular article is very important. But unfortunately, in our country, what we gathered is the president is not going to adhere to the things that are there in the constitution, and he is going to take his own decision. Because of that, people think this is abuse of power, and it is not important. But overall picture would be that it is very important, and people will get the benefit if it is properly instituted.
Right. The implementation process is what needs to be looked into specifically. Also, sir, considering what you just mentioned, how there is an issue with how presidential pardons are handled in Sri Lanka, what about the transparency of the entire process? What can you speak on behalf of that relating to transparency? Do you believe we have adequate transparency? Is there room for improvement when it comes to the process?
It's a good question that you have asked. My personal view is, having gone through this, I personally believe there's calling a report from the judge is unnecessary, because the judge has given the order. So finally it has gone up to the Supreme Court, and the Supreme Court has affirmed. So getting a report from the particular judge who heard the case is unnecessary. But instead of that, I personally believe that there may be two or three people, eminent senior counsel, president counsel, two from the unofficial bar, one from the official bar, should go in through all the details and give necessary guidelines to the president, because the president is a layman, so he is not thorough with the law, and the facts and the law is very important. So after going through all the details of the particular case, if they can give some sort of, after getting Attorney General's views as well as the minister's view, then they can go into that and finally give some guidelines or give some material to the president to take a firm decision. So in that aspect, they can hear the aggrieved parties' grievances as well. So finally, if they can take up that type of a thing, it would be a very transparent thing, and it should be included in this particular constitutional amendment, which I believe it will give more benefit to all people, because then they can get the things move.
Right. I think it's important for us to focus on this aspect as well. We just briefly touched on it, sir, when you mentioned about the 19th Amendment and how presidential pardon decisions can be challenged in court, and the judiciary can actually overhaul certain decisions made relating to presidential pardons. How do you believe that affects the entire significance of getting a presidential pardon? Do you believe that undermines the effect that a presidential pardon has, or do you believe that it's a necessary check and balance that should be implemented?
Check and balances are very important. That is the very reason they have given some guidelines also in the constitution itself. So check and balances are not properly done in this scenario. Even the United Kingdom also, they say the review should be there to have the president pardon reviewed. So that in that type of situation, 19th Amendment has given the power to do that. Before that, I personally, before you go to Supreme Court, if we are in a position to have the correct procedure, and then transparency would be very important, and then thereafter it can be argued whether it has been followed or not, the proper procedure had been followed or not. But the material factors are there, should be there. Otherwise, for the sake of taking a person's one case and then given him pardon because of political reasons or favoration, that is not correct. So president should be educated about the particular case properly. That's why I said 3 eminent people should be there for to give some guidelines, because they know the balance pros and cons of the particular case, and they can go into that and say that it can give necessary proper guidelines to the president. So after that, he can take a good decision to benefit of the particular case.
Right, sir. And relating to any specific case that we would have to consider in the presidential pardons aspect, every case, every judicial decision has victims behind it and has aggrieved parties. How exactly does the process of presidential pardon approach aggrieved parties and victims? How does that translate, sir?
Now, aggrieved party is there, whether that party is in a position to say this person is the person who has done the crime is the issue. Now, the court will go into that according to the evidence available. If the evidence are not available, then the judge can't go voyage of discovery. So this is our law. So this particular aggrieved party should be informed. You all have not seen the crime. We know your grievances. So, but the fact remains, he had been convicted because there was no proper material available. So it was not brought to the court in a proper way. So for example, now in a case where the contradictions and omissions are there, if the High Court case is going on, this lawyer is not going to mark the correct contradictions, material contradictions as far as the identity is concerned. If the lawyer is not going to mark those contradictions and omissions brought to the notice of the court, the omissions are brought to the notice of court. So that is how it goes. So if those omissions are not brought to the notice of court, then the Court of Appeal or Supreme Court cannot take a decision, because in the first instance it should be marked and proved. So if those contradictions are not marked and proved, then unfortunately the accused has to suffer. So then thereafter, final judgment is delivered, he was convicted, but the material contradictions are there. So that factor can be considered by the president and take a decision. So then when the aggrieved party are being represented, they can be educated that because of this lacuna or this error, we are going to give him the pardon. We say that the benefit of the doubt should be given to the accused. On that basis, we are going to give them a pardon. But we know that you all have been suffered, and you all have not seen and you all are not given the correct evidence in court, and that is why we are going to give them the necessary pardon. Then only the people, the aggrieved party also can understand what actually happened. So if the illegal evidence had been taken into consideration and it was not brought to the notice of court, then of course the president can take a decision. So that is the main reason behind to include that Article 34 subsection 1. In America as well as the United Kingdom, they all have those things, but the fact remains the law is there. But whether the law is going to be abused or not is the issue there. So we must understand in each and every law it is important and it should be there, but the people who are going to, authorities who are going to implement that should be very careful, and if they are going to abuse that, the Supreme Court has the power to review that decision and finally take a decision.
Right, so there are necessary checks and balances, but it is up to authorities in order to maintain that there is no injustice carried out through judicial processes and through what is initially meant to bring justice to people. Well, unfortunately, we've run out of time in this segment as well. We do have to touch on a specific area you mentioned, sir, relating to the global standards as well and how our presidential pardon system and our judicial system actually translates in that context. But before we get into any of those specifics, let's go in for a short commercial break. You're watching Law, Land and Liberty. We'll be right back. Welcome back to Law, Land and Liberty. We are in our final segment in discussion with President's Counsel Silva, and we were talking about the presidential pardon. So thank you very much once again for the insightful first two segments. I believe our viewers would have a good overview on what exactly a pardon is and why it is essential to have in our legal framework and how it can be used for good rather than the negative connotations that we see relating to pardons in Sri Lanka. I think it's important for us, before we get into any of the international context and how we translate in those aspects, could you please explain to us now, we understand that now the public has some sort of say over the decisions made via presidential pardons, and we can actually go and contest such decisions in court. But how big of a role does public opinion play when it comes to influencing presidential pardons in Sri Lanka? I understand that it's a very specific process, but does public opinion have any sort of correlation to such processes, or is it completely irrelevant?
No, only people should discuss these matters, but people should understand without giving proper instances, proper evidence. You can just, if you are going to just say that it is not relevant to our country or it is not good for our country, it's bad. Presidential pardon should be there, as I told you, in a lesser offences where people have been convicted and sentenced to jail, unnecessarily they are languishing in remand, and then who is going to look after them? Even the people are there. We have to look after them. So we have to our tax money is there to look after them. So unnecessarily, if they have been looked after, then it's not proper. So that is why the heavy fines will be imposed, and if they are not in a position to pay that fine, then the president will consider to release them. That's a normal process. And then very old people, if we are going to, for the sake of keeping them in remand, I personally believe that it's not proper, and then they can be released to go home and be there in their final stages with the family members, and for that purpose presidential pardon should be there. So because otherwise the president authorities can't take a decision. So if they are going to release those people, they have to inform the president about the conduct of those people. There are boards they are inside the prison where they recommend these people should be given some sort of benefit. That is, now if the person is being given a death sentence, if he has served some sort of time in the remand prison, President can consider him to give a pardon, in the sense not to release completely. His death sentence will be bring down to life imprisonment, then the 20 years imprisonment. Thereafter, considering all the facts that he has served the sentence for such a long time, then the president will give him a pardon later. So likewise, there are various remedies that can be adopted while considering the president pardon. So that is with regard to the sentences are concerned. If the 20 years RI being rigorous imprisonment is being given, then quite some time, if he has served the sentence, then President can consider giving him a lesser sentence, or else he can consider to give him a pardon to go home. So in that context, there should be some sort of remedy, and that remedy is considered and it is being recognized, so it should be implemented in a proper way. Mostly the death sentences are concerned, we are not in a position to implement the death sentence, because we have had agreements with other countries, especially fundamental rights are concerned, and because of that we can't implement that. Though we formally say death sentence is imposed, and but they can't go into that, implement that, though we tried to do that during President Sirisena's time, but unfortunately we can't do that because of those agreements. That is also people should understand. Some people say because of this crime situation, they say death sentence should be implemented immediately. No, we can't do that because of the situation that we are facing. We are not a lone country, we are with the other countries as well, so we have to agree with the other
there are balances
people
that need to be carried out in order to actually maintain peace with the other nations as well.
That's correct, and because of that we have signed some agreement. Because of those agreements, we are not in a position to implement the death sentence. So President will know that, and then it is unfortunate to say that it should be implemented because of those particular areas are there. Then if we are not going to implement those death sentences, we are in a position to see whether we can consider in different cases, case by case we have to take into consideration, and then if the cases are there where it should be given, the pardon should be given to them, then the president can consider those factors. So that is why I say president is the person who is going to take up this decision, but in our history there are various unfortunate incidents where president has taken, various presidents, they have taken unnecessary decisions about releasing people. So that is not correct. Those things should be discuss and say it's wrong. We are in a position to say those decisions are wrong, but that does not mean we should abolish or done away with that, because it is very important, it's very helpful, and it has served a lot of things to the people who are necessarily they think that they are being harassed, or they are being, unfortunately, the miscarriage of justice is there. So what we say is because of the public interest, the president should take decision, and checks and balances are there. And now in our country, after the 19th Amendment, if the president is not going to take up that decision in a proper way, we are in a position to go before Supreme Court and get the relief done.
Right, sir. And finally, before we end this discussion, sir, how do we fare in relations? Now, you mentioned that we have very sensitive relationship in relation to the death penalty as well. We have agreements with other nations, and fundamental rights come into play. When it comes to presidential pardons, how do we fare in relation to the rest of the world and global standards? Do you believe we have a good footing?
Yes. comparing to the other countries, especially as I mentioned earlier, now during Obama's time, 1,700 people were released, given pardon, and then Trump has given 150. Those are the available material. So those countries also, in some way, the president has abused. But that does not mean that particular concept is wrong. Likewise, in our country also, there are few areas, gray areas, where we should know that, and then we should go before Supreme Court and challenge it. That's a different matter. But the fact remains that it is essential, and we have done a great thing by releasing necessary people who deserve to get president pardon. Unfortunate incidents are there. It can be challenged, and it has been challenged up to now.
Right. I think that's the perfect note for us to unfortunately end this discussion on. We have run out of time, sir. Thank you very much for taking the time to actually explain to our viewers the essential nature of presidential pardons and why we do need it. And it's better off that we have it in our legal systems rather than having it done away with altogether. Thank you very much, sir.
Thank you. Thank you very much for inviting me.
All right, well, pardons are not just a weapon of lawlessness, but rather a sacred chance for wronged citizens to seek salvation. Therefore, it's important that we each do our part in understanding its intricacies and effectiveness and utilizing this function for the better. We leave you tonight with the words of philosopher Friedrich Nietzsche. If there is something to pardon in everything, there is also something to condemn. That is all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/Derana English. Thank you for watching. Have a good night.